Hello, and welcome to Politics for the People. I'm your host, Michael. Thanks for joining us today. Apologies for not having a new episode last week. We've been having some technical issues on our end, which is also why if you're watching on YouTube, you'll notice that there is no video for this episode. Again, apologies. We hope to get that back up and running soon. So, before we dive into the episode, of course, please do follow us on social media. Check out our Instagram at Politics for the People Podcast. Check out our Twitter, Politics People Pod. That's Politics PPLPOD. And please do check us out on Patreon, whether or not you want to support the show in that way. Of course, we hope you do. But you will also find an archive of all of our episodes there, as well as supplemental materials, and of course, for our patrons who do subscribe, exclusive content there as well. So we hope you'll consider joining us. So for this week on the episode, as I was looking at all the different things going on and different topics that we could cover, I was looking back on some of the news stories, and one thing that caught my eye that really got no attention, and perhaps rightly so, because there was so much else going on, was that the Supreme Court dropped the emoluments case against President Trump. I guess it's not right to say dropped. They never picked it up to begin with, but that case was making its way through the court system, and an appeal had been filed to hopefully have the Supreme Court look at it, and the Supreme Court decided not to because he is no longer president, so there is no violation currently taking place. If you go back in our episodes, you'll see actually 2 episodes of the Supreme Court. It was such a weighty topic. We really thought that it deserved 2 full episodes, and I think it was a good idea in the end that we did that. So if you want to know more about the history and kind of our traditional episode about the Supreme Court, please do go back and listen to those. So this episode, we're going to talk more about the actual procedures and functioning of the Supreme Court. So for instance, how do they select what cases they're going to hear? What does it mean that they're going to hear cases? How are the decisions made? And then how are the opinions written and presented? So just to get some general stuff out of the way, the Supreme Court schedule is divided into what is referred to as sittings and recesses. Sittings is kind of what we think of when we generally think of the Supreme Court. It's when they hear oral arguments, they go about their general business. If it's appointing someone to the bench, if it's deciding what cases they're going to hear, or actually hearing the cases themselves in the public sessions. And then you have the recesses, which sounds like they're not doing anything, but is just poor naming, because the recesses are actually fairly busy for the justices. They study cases that have been argued, as well as cases that are forthcoming. They work on opinions that will be presented soon for cases that have been argued, and they evaluate petitions of cases where people want to be heard by the court. They want to argue their case before the court, and they've gone through the proper channels, and they've submitted these petitions to hopefully be accepted. And that probably sounds like a small job, but in actuality, it's a fairly large one. Just think about how many cases people want to be heard by the Supreme Court. They've appealed the case as far as they can go, and now the last step, in hopes of getting the outcome they want, is the Supreme Court. All of those petitions are compiled and divided among the justices. But of course, the justices can't do all of this work alone, so they have clerks who work for them. Each justice has 3 to 4 clerks. They're typically recently graduated law school students who are usually from top schools at the top of their class and have worked in some capacity with another judge, a federal judge or something clerking for them. So they have some experience before they come to work for the Supreme Court. And these clerks are actually a much more important position than it may seem, because in addition to being research assistants or helping them to sift through the mountains of paperwork, they also act as sounding boards for the justices to bounce ideas off of, or just to bring another perspective into the room when they're considering cases. So as I said before, when those petitions are submitted, they're divided among the justices, and since the justices can't look at them all themselves, they have their clerks help. After the clerks review the cases, clerks issue memoranda, kind of summarizing the case, and a recommendation as well of whether or not they think the Supreme Court should take a look at this case, if it's appropriate for the court to look at this case. Then the next step for case selection is the justices convene in a conference. At this conference, they do a number of things, which we'll get to later, but while they're considering these different cases, they'll vote on them. And each case must receive at least 4 of the possible 9 votes to be heard by the court. This is also partially why that 6th vote is so important. This fall, after Justice Ginsburg passed, when the Senate was rushing to confirm Justice Amy Coney Barrett, a lot of people were saying, why does this really matter? They already have a majority. Okay, so they have more of a majority. They already have it. Well, there is a big difference between a 5-4 majority and a 6-3 majority, because a 6-3 majority also has control over what cases will be heard by the court. So once a case is accepted and will be heard by the court, both the petitioner, the person asking the court to take a look at this case, and what's known as the respondent, the other party in the case, write briefs, which must be less than 50 pages, and the court sets a timeline for when these briefs are due. And the briefs really summarize the merits of the case and present the actual arguments. Because during the oral argument session, that's not actually used for the arguments. So arguments are heard generally between October and April. Each side is given 30 minutes, and they're actually used more to answer any questions that the justices may have. The justices have already read over the petitions and the memoranda written by their clerks. They've done their own research, and they've had the briefs, which have been submitted by both the petitioner and the respondent. So they really want to use that allotted time to ask any questions they may have and really give the people arguing the cases the opportunity to say what needs to be said, rather than what they think needs to be said. After the oral arguments are heard, as I said before, justices really like to bounce ideas off their clerks. They go over the case, the different ideas presented, the merits of the case, and they work with their clerks because they want to get a different perspective. They want to try and consider the case from as many angles as possible while they make their decision, because, of course, the Supreme Court is the highest court, so that decision is final. After their consideration, the justices go into what are referred to as conferences, which I brought up before. Now, at these conferences, only the justices are allowed in. Their clerks aren't allowed in, no press or public are allowed in, there's no recording. It's just the 9 justices in a room together to talk and vote. So each session starts with the Chief Justice calling the session to order, and all of the justices, as a show of unity and respect, all shake hands. Of course, they're probably not doing that right now in the COVID era, but normally that is what would be done. So once the session has been called to order and all the justices have shaken hands, the actual business of the conference starts. The justices review all the petitions that we talked about earlier. They discuss all the cases that have been heard since the last conference, and they actually get to work voting on the issues. What petitions will be accepted, And then, of course, actual decisions on the cases. So as the justices approach these issues, it always goes in order of seniority, but starting with the Chief Justice. So that goes for both the discussion of cases and voting. While they're discussing cases, each justice gets their time to talk uninterrupted. They get to present their opinions, their concerns, any comments they may want to make, and then it moves on to the next justice. Once all of the justices have had a chance to speak, they actually get to work voting. And the votes follow the exact same order, starting with the Chief Justice and then following seniority. Once voting has completed, the Chief Justice or the senior justice in the majority, if the Chief Justice is in the minority, pick someone to write the majority opinion. And the same goes for the dissent. In the event that there is a tie, if there are only 8 justices currently sitting on the court, or if one of the justices has had to recuse themselves for any reason, and there is a tie, the lower court's decision stands. One important note here is these votes aren't actually binding. These are the votes to see who is in the majority, who is in the minority, and then who will write the opinions. But the votes themselves aren't actually binding until the opinions are written and publicly disclosed. The opinions are typically released on the last day of each session before the recess, but there's no requirements on when they have to be released. It's completely at the discretion of the court, and we've often seen important decisions be released as soon as possible. But because the votes aren't binding until the opinions have been published publicly, a majority of justices must agree to the contents of the actual written opinion before it's published. And it has happened where a justice disagreed in part with the majority opinion and became a swing vote, and the minority became the majority. So the decision was actually reversed before it was ever publicly decided. There are multiple cases still making their way through the justice system right now, headed for the Supreme Court. We know for a fact there's at least one case on the Affordable Care Act and the constitutionality of the law that's currently making its way towards the Supreme Court and will be heard soon. So we just wanted to make sure that we all had a solid understanding of what that process is like, what the Supreme Court does, so that ultimately, whatever the decision may be, we can hopefully better understand how the justices arrived at that decision. Thanks for joining us and listening either through your favorite podcast app or on YouTube. Please, if you haven't already, do subscribe and do follow us on social media on Twitter at PoliticsPeoplePod. That's at PoliticsPPLPOD, or on Instagram at PoliticsForThePeoplePodcast. You can also email us if you like at politicsforthepeoplepodcast@gmail.com. And please do subscribe to our newsletter if you haven't already. It's a weekly newsletter that comes out on Wednesday mornings and really goes hand in hand with the podcast to talk about more current events, what's going on at that time. So check it out. All this information, all the links, including how to subscribe to the newsletter, will be in the show notes or the description box of this episode. Thanks for listening, stay safe, and we'll be back soon with another episode.